right, so for this video, we're going to talk about an Act 3 motion. So this is a very special motion that we file in certain cases. And under our system, you can't be criminally responsible if you couldn't mentally appreciate it and understand it. And so the law that came out, it was Act 3 when it came out. So we all refer to this as an Act 3 file. But basically what we're saying is that you have a mental illness or a condition that prevented you from understanding the consequences of what you're accused of doing. And so in layman's terms, what we're saying is that you're too crazy to be held criminally responsible. This isn't going to be available in every case. It is going to be available in some, and we will have a discussion about it. So this is really going to come into play is if you've been diagnosed with schizophrenia, bipolar, something like that, where you've got a real serious mental condition that's going to prevent you from being able to function, so to speak. Now, just having anxiety, PTSD, that sort of stuff, that's not going to cut it. So the way that it works, we have to work up the formal motion, and we have to file it to the court. We have to give notice that we're going to rely on this defense. And then when we file the motion, it puts the case on pause. And then the state is going to have a doctor evaluate you, and it's free of charge. You don't have to pay for it. And if they find that you're mentally fit, then we proceed as if anything else. But if they find that you're unfit, then we're going to be able to get rid of the case for you, which is the good part, and you're not going to go to prison, which is also the good part. The downside to it is now you can get committed to the state hospital. For folks that are facing some serious mental issues, going to the state hospital is going to be a lot better for them than nothing at all, and it's going to be a heck of a lot better than going to prison. But we do understand some folks have a problem with me basically saying that they're too crazy to be able to function. We understand that. We appreciate that. That's why we go over it with you and with your family. Now, it can be followed without your permission, and some folks are just so gone that that's what's required. We generally take the approach of we're going to visit with you, visit with close family members. If that's not the route that we want to go, then we're not going to do it. And just because we file it doesn't mean that it's going to work out for us. And we've had cases where we really thought the client would be found unfit, and they got evaluated and they were found 50% and everything was fine. I got surprised by one not too long ago. And then we'll hear about other cases where we thought an Act 3 wouldn't work, but then it somehow it did. It's not the first thing that we want to raise in any case, but especially if you're facing a really, really serious charge, and then you've had a medical diagnosis of mental illness, something like that, then we're going to take advantage of this and try to use it as another tool to protect your freedom. It's something that we'll have a serious discussion about, get your input on it before we file it. But it is another tool in the arsenal, something that we have there, but it's not something to be taken lightly. That's how an Act 3 works. Thanks.